All right, David, I believe we are live.
Thank you, Brian, and thank you all for joining in this morning. This is the spring quarterly meeting of the Ethics Committee of the North Carolina State Bar. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest or the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or the appearance of such a conflict. If anyone has, from looking at the agenda, has noticed a conflict or such an appearance, you can let us know now or let us know when that agenda item comes up. Thank you. And I do want to say one word as we gather for I think this is the 5th time for our Ethics Committee meeting on Zoom, and it seems like it may be the last. I'm certainly grateful for that, although I think we would all be remiss if this is in fact the last time we have to Zoom together. But I didn't take this opportunity to thank you all. The committee members, advisory members, and certainly staff have had to live with the extra burden of dealing with these committee meetings by Zoom, and I think we've acquitted ourselves quite well. But I do think that staff, Brian and Peter, Suzanne and Nicole, deserve an extra ration of grog from the mess for having to do this. I know yesterday I had a WebEx hearing in the morning and then meetings all afternoon. And not only did I have Zoom fatigue, I had, if you'll pardon the expression, fanny fatigue by the end of the day. And that's just happens for all of us with these Zooms. So as Davis mentioned, I look forward to us being together again, at least in some fashion, in Asheville for the summer. Please note, by the way, that the State Bar has asked us if you don't mind to inform us about your status with respect to vaccination. It can be anonymous, but you should please let people know. We're trying to get sort of a gauge of people's feelings about live and particularly about their vaccination status so that we can make some planning for that. Our committee is a very large committee, and so we'll be space accommodating, but it would also help us to know a little bit about your vaccine status if you don't mind sharing that anonymously with us, with Sharon. Thanks. Those are my personal points of the moment, and now we'll launch into our agenda. Unless anyone has any questions or comments about that. I do know that I think we have one new member, and at least I believe that's correct. Davis, is this your first meeting to join us?
This is my first ethics committee. Yes, Rick Buckner stepped down at the beginning of the year, and I was elected to take his spot last month. Well,
welcome to our committee, Davis. You missed the ritual that I subject all members to in January, which is to go around and tell us who you are, where you practice, and a little bit about your practice. And so we'll put the intense white Klieg lights of you, on you, so you have the whole meeting to yourself. Please tell us about yourself a little bit. Give us a little note.
Sure. So Davis Poisson, I practice primarily personal injury law, do various other types of civil litigation, some consumer law as well. I practice in Anson County in our Wadesboro office with the law firm of Poisson and Bauer. I've been practicing just now around 7 years. And I think that's about it.
Great. Well, welcome aboard. You have a heck of a legacy to overcome from all the presence of others of your family on this committee. Luckily, that will not be a cross too heavy for you to bear, I'm sure. This may be Roy's first time with us. Is that what I don't see him on my screen, but yes. Roy, are you here with us? Roy McDonald?
Yes, and I just figured out how to unmute myself.
Well, that may be a good or bad thing, depending on how you use that power, Roy. But welcome. Is this your first time with the Ethics Committee, Roy?
Yes, sir, it is.
Okay, well, we'll allow you to share the spotlight then a little bit. Tell us a little bit about yourself and welcome to this body.
Thanks. I practice in Lexington at Brinkley Walser Stoner. I'm primarily a litigator, but I also do some corporate work. I'm a major in the Army Reserve, judge advocate. That's about it.
Well, good. Well, welcome to you. You also, working at the Brinkley Walser firm, have a wonderful heritage with the state bar and with our bar in general. So we welcome you. And guys, our committee works best when everybody participates and brings their own points of view and experiences and nuances to the ethics committee. We're called, despite what the U.S. Senate was formerly known as, we are actually one of the last great deliberative bodies on the face of the earth. And so we encourage you to participate. There is no rule of standing that you have to, watch for a term or two before you actually participate. So please feel free to give us your comments. There is a number of our matters that we will discuss this year are ripe with age. And so if you need some help in getting some of the backstory, do not feel reluctant to ask us, well, how did we get here? Because a couple of them are hoary with age, as you might expect. So, but welcome aboard. We're always glad to have new folks join us. It keeps us fresh and new. So thanks. Started with our agenda, the special agenda items, administrative matters. Ann Parkin, can you give us a report on the trust accounts? That was attached to the materials, but just tell us a little bit of an overview of what you did this past quarter, please, ma'am.
Yes, good morning, everyone. Audits continue to be conducted remotely. Hopefully the upcoming quarter will be the last one, and I can get back to on-site audits. Audits for the past quarter were conducted in judicial districts 13 and 36. District 13 was last audited in 2015, and District 36 was last audited in 2014. 17 audits were conducted in District 13, and 26 audits were conducted in District 36. The two most common rule violations were that 40% failed to perform quarterly transaction reviews, and 35% failed to sign, date, or maintain reconciliation reports. Audits for the next quarter will be in District 20, composed of Robeson County, and District 25, composed of Cabarrus County. Any questions?
Thank you, Ann. And I would urge you guys, when you go back to your districts, men and women, I'm sorry, but I'll just use guys generically, but when you go back to your districts, please remember to alert your constituency to the fact that these same audit issues come up every time. And I mean, Ann is not a broken record, but she encounters the same sorts of issues every time. And so please try to highlight that for them. I also encourage folks to call the state bar with audit questions. I actually called Ann with a trust account question this week. Due to her schedule and my schedule, we hadn't quite hooked up yet, but the bar is very accessible, and a lot of those questions are pretty simple ones that Ann or others just carry around in their heads. And so if you can encourage folks to call, that would be a great thing. Thank you, Ann, and we'll release you. I'm always happy to have you, but you can go and be more productive somewhere else, I'm sure, than listening to us. Speaking of being unproductive, Suzanne, can you give us a little insight, if you would, on the ethics calls that we have received in the past quarter?
Suzanne, you're muted.
Yep.
Okay. I was saying that we were very productive this quarter. Thank you very much. We were down a little bit last quarter, but we are right back at it. This quarter, we had 1,231 inquiries that we responded to. And the top 5 categories this time were conflicts, confidentiality, advertising, UPL, and trust accounting. So there are some trust accounting questions that Nicole and I are able to answer in addition to Ann. But looks like lawyers are back at work and keeping us busy again.
Great. Well, thank you. The ethics hotline continues to be, although a well-utilized tool for us, a tool that is to some extent still underutilized. People don't really realize it's out there. When you tell people, just, why don't you just give Suzanne or Nicole a call? A lot of times they will look at you like, I don't know what that means. And so it's amazing to me that after all the years of us trying to tell people to do that, that people are still uninformed that that's a service and a great service that the State Bar offers. So again, push that out there to the extent you. Thank you, Suzanne. And Brian, tell us about some CLE presentations this past quarter.
Sure, we had a lot of CLE presentations this past quarter. Actually,
Uh-oh.
hello. All right, there we go. We had a lot of CLE materials, or excuse me, CLE presentations. I keep on getting muted. I don't know if
Maybe
what's
Peter.
going on with that. But nevertheless, we have 12 presentations and materials. We actually had 13. Nicole presented another one yesterday afternoon. So we're continuing to be out there trying to educate folks and provide these different CLE opportunities. And just really, I think, in addition to reminding folks and helping folks understand their different requirements, the professional responsibility that they have, that we all have as lawyers, also putting a face on the State Bar to let folks know that, like you said, David, we have a resource that's called the Ethics Hotline, and we absolutely want people to take advantage of that. So if you in your districts have a need for a CLE presentation, or in any of the different organizations that you're involved in, please don't hesitate to contact us if you would like us to appear, especially since we're doing all these different things virtually. It's much more convenient for us to be able to attend an event perhaps that we wouldn't otherwise be able to attend due to travel considerations in previous years.
Did you say there were 13 this past quarter, Brian?
We did 13, yes. I did 10 and Nicole did 3.
Gee, well, that's, yes, you can see the heavy utilization. That's up from a normal quarter for us. And I guess virtual makes that, it makes us more accessible, but that shouldn't be lost on us going forward. Although I hope we'll be able to return to live presentations. There's no reason that we couldn't zoom in to various bar functions to provide an hour of CLE, which is always necessary. Speaking of which, and I'm sorry this is off agenda, just a gentle reminder, I think your statements of economic interest, I think today is the deadline for those, counselors.
That's correct.
If you have not filed your statement of economic interest, those are due today. And also, I'm sorry, Suzanne, I'm going to put you on the spot. There was an email you sent out about making sure that we all complied with our ethics commission requirement or something like that. Can you give us just a brief snippet on that?
Thank you for putting me on the spot. All the new counselors have to do an education class and file an SEI. The SEIs have to be filed every year. Education, I think, is every couple of years. Just if you have any questions, just send me an email. I can check your status. I can help you figure out how to do a course if you need to. So I can't say the specific requirements off the top of my head, but if you're not sure, shoot me an email and I'll check on your status for you.
Because we have to, every couple of years, as I think, maybe 3 years, every so often, you have to get retrained, I think. Isn't that correct?
Is it 2 years or 3 years? But yeah, something like that. You have to redo the education course. And it used to be really easy to do it online, but then somehow their system got messed up. And so you either had to do it in person or through a scheduled webcast. But they understand that that's difficult for everybody. And so they're being, pretty lenient about it at this point. But like I said, just check with me if you have any questions and we'll get it figured out.
Just a general reminder, if you haven't had your refresher course in the last 2 or 3 years, I know that because I'm up this year. Suzanne was nice enough to send me, and I'm scheduled next Tuesday. So just to remember that's something you have to do sometime in the next little while. Now, finally, we're on to the actual agenda items to take up the rule amendments. This will be section B of our items. These are the first matter to be considered is the study in consideration of adopting anti-discrimination language into the preamble and into the rules of professional conduct. This is a matter that has been, we first undertook this at the summer meeting last year and has been moving forward for the last little while. Steve Robertson has been nice enough to chair the committee to look into the rule change. We also added to him in December a question about the change to the preamble. So Steve, can you give us a report on the status of those two, sort of your dual mission with respect to anti-discrimination language?
Thank you, David. The committee looked at adding a requirement to Rule 8.4 that would be enforceable by the State Bar and be part of our rules concerning anti-discrimination, and adding language that certain identifiable classes of people should not be discriminated against. And we spent some time being educated on the constitutional aspects of that, and then got into some practical aspects of it concerning if we had such a rule, what would enforceability look like. Other states have considered this. We also looked at the panorama of what's going on around the country. And there was a case that came out of Pennsylvania where, in fact, such a rule was struck down by the federal district court because it ran afoul of the First Amendment. There may be ways to draft around that, and our committee is still considering what we may want to do in terms of an enforceable rule. However, when we were tasked with the preamble part of this in December, we shifted gears and decided to focus on that. There was, and Brian, you can correct me if I'm wrong, but I think we did publish a preamble language at some point. Is that?
Yes, we published back in July 2020, the State Bar Council published a proposed amendment to the preamble that really mirrored or was very close to the original proposal in 2010. But we did receive a fair amount of comments, I believe over 100 comments that represented over 200 lawyers, and
Right.
that sent it back to the subcommittee.
Thank you. That was where I was going with this, Mr. Chair, is that there is a organized and vocal opposition to certainly to a rule. And we felt, given that the preamble is not an enforceable rule, that it's essentially aspirational language that that all lawyers should aspire to, and it's a fairly long preamble, frankly. But what we decided to do was to publish that, to recommend this committee publication of another version of that, I should say, and see what comments, if any, that brings. That's going to be our recommendation today. And I should say that staff, which is Brian and Carmen, have redrafted the preamble language. And what they did was take the first half and sort of point out why anti-discrimination matters. And then the second half is the actual language identifying the categories of people where we think there are issues from time to time. Brian's put that language up on the screen, and I can read it. The North Carolina Constitution requires that right and justice shall be administered without favor, denial, or delay. Public confidence in the justice system is strengthened when all participants are treated equally, fairly, honestly, and respectfully within the system. A lawyer, as a representative of and crucial contributor to the justice system, should foster public confidence in the administration of justice by treating all persons they encounter in their professional capacity equally, courteously, respectfully, and with dignity, regardless of a person's race, sex, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. The chair, you have, Mr. Chair, I think appointed to this committee a diverse bunch of counselors from around the state, from different ethnic backgrounds, rural, urban, color, gender. And this is not at all controversial among the subcommittee members, whether it will be at this full committee or further our council or the bar as a whole remains to be seen. But But we are recommending today that this language be adopted by the full committee. That's my report.
All right, thank you. Is that a motion from your subcommittee, Steve, that the matter be adopted for publication?
Yes, we move the language that's just displayed on the screen be adopted for publication by this committee for publication.
Is there a second for that motion?
Second.
Thank you, Mike. All right, now we'll have discussion on this. Thank you. All members of the subcommittee. It's been a very hard-working subcommittee, and we gave y'all extra homework to do beyond what you had originally signed up to do, and so we appreciate your hard work. Questions, comments from, and what I'd like to do, guys, and we have visitors, we have other counselors. I'd like to hear from members of the subcommittee first, and then from the full ethics committee, and then from anybody else who wishes to participate, if you don't mind. So if you will raise your hand to indicate to Brian or to Peter that you wish to be heard on this topic, we'll try to manage any discussion or questions.
And David, I can just have a quick little moment to share this version that we're looking at. There was one grammatical change that I realized after publishing. Previously, it's in this sentence: a lawyer as a representative of and crucial contributor to the justice system should foster public confidence in the administration of justice by treating all persons the lawyer encounters in a professional capacity equally, courteously, respectfully, and so forth. Previously, it said by treating all persons they encounter, as opposed to the lawyer encounters. That is the only change, because we realized we were referring previously to the singular lawyer and then subsequently to the plural they. So that is a very small, minimal change, but wanted to make sure that everyone was aware of that. And that is the version that I guess that staff would recommend this committee vote on.
Thank you, Brian. You see the technical correction there. If you'll look just on the screen save we've got up right now, you can see C starts with, E starts with a lawyer's conduct, and F starts with a lawyer. So this is to continue in the singular pronoun there for, or to refer to the lawyer as opposed to they. Okay. Questions or comments from the committee? Or from anyone? Brian, are there hands, or Peter, are there hands raised?
I do not see any hands raised.
All right, folks, I don't want to push on to a vote, but if no one has any questions or comments, and if you don't know how to use voting at the bottom of the buttons, where have you been for the last few months? But you can just wave your hand. We're happy to.
Well, we have a poll that we will launch here. So when you're ready, David, then I'll launch the poll and everybody can vote on their screen. But the motion on the floor is to publish the language that was displayed on the screen, and I guess send on to executive committee for its review as well.
Yeah, this would go to the executive committee this afternoon, and then for the council tomorrow. All right, I think we can put the poll up. All in favor of the motion, please signify by saying aye. If you oppose, signify on your voting tabs.
All right, David, I think it appears to be unanimous. We have 32 votes in favor.
All right, great. Thank you. And thank you, Steve, for this part of your committee's work, and to all of the members of that committee. That's been a big committee, and a committee that has, as I said, worked very hard, and we appreciate y'all's hard work. We realize your work is not done. You still have other work to be done on the rule change, but the way that, as I understand, your subcommittee has handled this was to handle this issue, and then we'll be moving on to the next issue. Is that correct, Steve?
That's my understanding. Is our charge, and I thank you for the opportunity, and thanks again to the staff. And I think also I should give a shout out to Liza Foley, because she was involved in some of the work on our educational part.
Okay. Again, many thanks for that hard-working committee. The next committee has also been equally hard-working, and we have worked doubly hard as chairman. Brandy Vickery, who was a member of ethics when he was appointed to chair the committee to study the consideration of adopting a comment to Rule 1.1 on competency. Brandy, I guess as a result of that, fled to the Grievance Committee and has left ethics. But one of the advantages of Zoom is that we are able to have, in the normal course, Grievance and ethics, of course, meet at the same time, so we don't have a lot of overlap. But fortunately, with the Zoom, we're able to have some Grievance folks have visited in all of our meetings to watch the ethics committee, and also we benefited by their comments. And so, Brandy, do you have a report on the subcommittee on the consideration of adopting the change to Rule 1.1 competency?
I do indeed, David, and thank you for giving me the chance to be a part of this committee. We we've had a couple of meetings, and the first one was primarily an educational type meeting. I might have made this similar report at our last meeting of the ethics committee, but Jim Drennan spoke to us. He was extremely informative. He opened a lot of eyes, certainly mine. I've never thought of myself as particularly a biased person necessarily, but I realized, of course, that some of his training that I had when I was in the DA's world, but certainly now I still see it every day. He spoke a good deal about some things he got from a book, I think, years ago, and then his own work. He referred to the book Blind Spot: Hidden Biases of Good People. That's an extremely eye-opening book if you want to get a chance to look at that. Of course, getting down to my level and explaining things that I could understand, he made reference to it. Some of these biases we have, and maybe along the lines of an autocorrect within our brains. We see a little something, we fill in the gaps of things we don't see, and I think we know what happens sometimes with autocorrects. It's not always right when you start filling in gaps. But anyway, our second meeting was more of a got down to the question of, do we have or should we put into the lawyer's competencies requirements or suggestions that implicit bias awareness, should that be part of the comments? And I think that was, there was absolutely no, same as Steve, we had no opposition to that. Everybody seemed to be on the same page. So then the second meeting came down to what's the language we're going to use. And there's a good bit of discussion. Any of the members that are here today that might want to chime in, feel free to do so. But the language, as you'll see, or if you've read this already, we all agreed to the following language. Competency includes a lawyer's awareness of implicit bias and cultural differences relative to a client or anyone involved in a client's matter that might affect the lawyer's representation of the client. This is to ensure understanding of the client's needs, effective communication with the client and others, and adequate representation of the client. That is the language we agreed upon, and that would be our report out in the form of a motion to adopt and publish. I certainly welcome any other comments, particularly from committee members that might wish to be heard.
Thank you, Brandy. That's a motion to adopt the language and add that to Rule 1.1. Is there a second to that motion?
Rule to the comments to Rule 1.1.
I'm sorry. Yes, to the comments. I'm sorry.
Yeah, and if David, I can just clarify this. I think the motion is to publish, not to adopt.
That's right.
Yeah, that's right. I'm sorry, guys. So we don't really adopt anything. We have to move it through the system. I'm sorry. So this would be to publish this change to, or addition to the comment. Is there a second for that? Thank you. Okay, now questions, comments from members of the subcommittee or the full committee. Anybody else have any comments to be made? So these issues have been with us a little while. We've talked about them a couple of times.
This is Steve Robertson, if I may.
Yes, sir.
Brad Bannon has posted in the chat room a procedural question that I think is a good one that may apply to both the first matter before the committee and this one that do we need to send the preamble language, or in this case, the comment language, to the executive committee?
Yeah, and Alice or Brian can chime in here, but when we make changes to the rules or even at the preamble, anything that is not an FEO, we go before the executive committee to also alert them to what's happening and to get their imprimatur or comment on what we have adopted before it goes to the full council, and ultimately because these would have to go to the Supreme Court for adoption. So I believe the process is for those to go through the executive committee as opposed to the normal FEO kind of route where we would go directly to the council. But I'm happy to have more enlightened commentary on that from Brian or from.
Yeah, and I guess I'll just add, I think it's essentially the, I guess as far as procedural requirements, I think the really just everything funnels through the executive committee. Alice may be able to opine on kind of the history of everything going through the executive committee, but essentially coming from any of the standing committees or subcommittees or what have you, that essentially before it goes to council, it does go to executive committee. Now, whether executive committee can override the ethics committee's vote, that's a question that I'm not sure what the answer is. But if I know Catherine's on here as well. I don't know if Alice or Catherine have any other additional thoughts.
Well, I'm not going to opine on the history of the executive committee, but the procedure has been that amendments to our rules do go through the executive committee. We're looking for a recommendation from the executive committee to the council to publish and then, subsequently to adopt. And procedurally, that's the way we have done it. Brian, I don't want to get into that question of can the committee take something directly to the council? I suppose that could happen, but in terms of procedure, this is the way we've done it. It's been very efficient. And actually, if you don't have the executive committee support for a proposed rule amendment, either publishing it or ultimately adopting it, then it's going to have problems at the council level in any event. So procedurally, that's just the preferred way to go.
Great, thank you. See, Catherine also has her hand up.
Well, so I'm not having to think the way y'all are. So I went and looked at the administrative rules so I could cite you to the rule. And the rule is 27 NC Administrative Code, Chapter 1A, 1401, publication for comment. And it does provide that it must be presented to and approved by both the executive committee and the council. So that procedure has been codified.
Thank you, Catherine.
You're welcome.
Look at Catherine looking at the rules. My goodness. Why don't we all do that?
Catherine, can you give me that rule again? I didn't get all those subparts.
Yeah, I'll be happy to. I'm just trying to be more like Jennifer Porter. Instead of what I'm inclined to do, I actually now look at the rule.
Well, I apologize for not knowing chapter and verse, but thanks, Catherine, for setting us straight.
Thank you.
Mr. Chair, this is Darren Jordan. Can I ask you a question?
Oh, God. Okay. Yes, you may.
Well, I'm looking at your office, by the way, in Charlotte. So I just wonder if Catherine Jean or someone else can explain to us the effect of a comment with regards to one, the rule, and one, the enforcement of the rule that it's attached to. I'm not real clear on that. I'm just wondering what this language adds to the rule and the enforcement of the rule.
Mr. Chair, would you like me to try to address that?
If you have a citation that you could give to Darren, I know he'll be taking notes. Catherine, yeah, please do.
Well, I don't have a citation, but as a practical matter, when you're in a DHC case, the DHC is looking to determine whether there was a violation of a rule of professional conduct, and does look to the comments when there might be some question about what is the meaning of the rule. I'll give you an example of one that is relied upon fairly often, which is the rule about competency. It doesn't elaborate much. It's a pretty bare bones rule, but the comments do elaborate. And one of the things that they say is that an isolated instance of malpractice is not a grounds for imposition of discipline. And so that is, it is a way that that helps the person who's trying to decide whether a rule violation happened to look at these examples or comments that are in the examples that are in the comments of that type. Another one is in Rule 8.4D, 8.4B, that says that 8.4B being committed a crime that reflects adversely on the lawyer's character, etc. It specifies that it's not necessary that the lawyer have been charged with or convicted of the crime, just that they committed the crime. And that is another one that is frequently relied upon by the DHC when they're considering whether a rule violation has occurred. Is that helpful at all? No?
Well, I'm not in opposition to this. I'm just asking questions, but how does this language assist you in a rule violation for competency? That's what I want to.
Oh, this particular, you want to know about this particular. I don't know that I'm prepared to answer that.
I have a thought. Darren, this is Carmen. I'll say, first of all, we don't ever endeavor in the Office of Counsel to prosecute on the basis that a comment was violated. I don't think that's ever been the purpose of the comments, but I think the comments perform an educational service for members of the bar so they understand the context in which this rule may apply. And the two examples Catherine just gave are exactly that. They're examples of, what are the contours of the application of this rule? Where are its limits, and where are the areas where it might apply? And so I think that would be the purpose of this rule, just in the same way that we've indicated recently that technology is an area in which lawyers need to have some competence. This is a similar comment to that, in my opinion, that it serves that educational purpose to say there may be instances in which this rule could be violated due to a woeful lack of competence in, understanding of cultural difference. So that would be my thought.
Oh, David, your hand was up, and then Tom.
Sure, thanks. So I wondered if someone from the subcommittee on this issue could give some perspective as to where North Carolina stands as compared to other states who may have adopted comments like this. Is North Carolina, for example, on the leading edge of this type of comment, or are we way behind, or do we know?
I can respond to that if that's all right, Brainy.
Sure.
This is, from what I can tell, we would be the first state to adopt a comment of this kind that specifically recognizes implicit bias and awareness of implicit bias and cultural differences as a part of lawyer competency. The other subcommittee that Steve is chairing, dealing with anti-discrimination language in the rules of professional conduct, that is one where North Carolina, I guess, I don't know if I want to say behind, but certainly there are a lot of other states that have done that. I think 37 other states to this point have adopted some type of anti-discrimination language into their rules of professional conduct, be it in the text of the rules or the comments to their rules. So that's where I think we're kind of on different ends of the spectrum, depending on which issue you're talking about.
Dave, is that all okay? Tom, you had your hand up?
Yeah, I guess it's not really a concern, but I guess, I've done a little bit of reading on this notion of implicit bias as well as attended some trainings. And I guess there's disagreement within the scientific field as to what it is and how it's measured, and in some sense, how malleable it is within context, both geographically and socioeconomically. So, and I understand the foundational nexus of it and the purpose of it with respect to representation of clients in the justice system, but I'm not so sure that it's kind of a settled issue. I think there's research on both sides. I mean, and some articles are actually saying there's, we're not really sure what it is, because of the testing that has undertaken and been undertaken over periods of time, that it doesn't really exist in a spectrum continuously. It's malleable in that sense. So I guess it's not that I don't like mine being first in some respects, but I think there's contrary issues and views out there about whether it exists and to how you measure it. And then, because I think the reaction to others will be, okay, now we need to educate lawyers on this. And if we're educating lawyers only on the perspective that how it exists and what it consists of, then I think we're going to be pigeonholing ourselves into a situation where there are still unanswered questions about this.
Okay, thank you, Tom. Further comments or questions? I don't see any additional hands raised. Anybody else have a comment to make? If not, we'll proceed. I'm sorry, Warren.
Jack.
I'm sorry. I'll get you. I see Warren.
And Jack Lloyd.
Yep.
All I wanted to ask is, this is a comment. This has nothing to do with the consideration that there was about whether to require a CLE on the topic of implicit bias, right? This is just the comment to the rule, or is this do the two go hand in hand? I mean, I guess I just didn't understand what we're voting. We're just voting on this, and this is not part of the same consideration about that CLE requirement and whether to do it, correct?
This is just the change to the comment. Brandy's committee has met. I know it had contact with the CLE board. Brandy, you wanted to give us any enlightenment on that? But this is just on this language, nothing further, Warren.
Okay.
Yeah, this didn't have anything to do with the CLE. It's purely the aspirational language that you see here being placed in the comments to Rule 1.1. Like Carmen so adequately told us in our meeting, we were concerned about whether this was something that was going to be brought up as a violation of a rule. It's not a rule. It's a comment to the rules to give guidance to future issues.
Yeah, we got all kinds of comments that are educational,
right,
to these rules. Yeah, thank you.
And now I saw Jack. So Jack.
Yeah, no, thank you. Right. Well, I mean, I think there's some great points raised here. And if I could just for a second share with you, I think that the key here is this language that you guys included that might affect the lawyer's representation of the client. And I love that language because a young Muslim attorney who wants to represent an elderly Jewish couple in analyzing a mortgage contract, clearly they don't have to study the Torah before they can do it, right? They don't have to be aware of everything about Jewish history before they can do their job to analyze the contract. So I really like that. But the quantifiability piece is really tough, and I think that I love aspirational language. I think aspirational language has its place. Like the preamble, I thought was great because I think it shows what we're doing as a state bar. But as we go from that preamble to the comment and then to rules, quantifiability is really tough, right? And having participated in drafting legislative language, I can tell you that squishy, undefinable terms that feel great when we're writing them become a real headache later on. And I'll just share this with you. So I'm a legal aid attorney, for those of you who don't know. And as part of my training during the last couple of years, I have had the privilege of working with a few psychologists and psychiatrists at Duke, not for me, although I probably could use it, but to learn about what's called intergenerational trauma. And I won't go into it here. I'm not an expert on it, but I will tell you that training enhanced my ability to be a better advocate for my clients. And it was undoubtedly a good thing that I learned and helped me be a better lawyer. However, Does that mean that the cases I handled before I took that course last October, I was incompetent on, right? It's like, so the quantifiability thing, what that Tom was raising and the gentleman on the phone there was raising, I think those are real issues. And I would just say, for as much as I'm supportive of this particular piece, voted for the preamble and will vote for this, I just think that if we transition toward trying to make an application of squishy, undefined terms, having watched that happen drafting legislative language, I would just, sharing my piece, would just say to be very careful, because squishy language does not make good law.
I see we have a couple of hands up. I will say this, that when we have tried to interpret for FEOs and we've looked at the rules, we often look at the comments as we try to shape future FEOs as we're drafting them. And I've been told by lots of folks on Grievance, who are actually who had been on Grievance and now are serving on ethics, and we don't enforce the comments. We don't enforce the comments. They are just there to provide guidance. They do provide wonderful guidance to us in terms of shaping future FEOs, because it embodies it puts gloss, for lack of a better word, on what the actual rule language is supposed to be for interpretation or additional comment. I'm sorry, Judge Bell had her hand up, and then Professor Murphy.
Thank you. I would say that, I've been on the bench just under 4 months, or right at 4 months. And what I have observed in that time from this perspective is that many of the courtrooms that I'm in come down to credibility, because people say, I know you can't imagine, but each side says something different. And so you're supposed to believe, you got to figure out who to believe. And how do you decide who to believe? You decide who to believe based on your comfort level of what they're saying, their credibility. Can you relate to them? And all of that information, there is some bias that you come to the bench with, that you come to court with, that we operate in our everyday lives with. We unconsciously make decisions when you're riding down the street. Is this safe? Is this unsafe? Maybe it's justified because you see something, something happening, but maybe it's not justified, but it's at least a question that you have to raise. And when I'm trying to decide credibility, I'm trying to listen through. We spent some time in New Judges School talking about this. And so I'm trying to say, am I concluding something because somebody's more animated about it versus somebody who's less animated about it? Am I making a decision based on that? Am I judging rightly? And so I do think we all have these things unconsciously that we look at and conclude, even if it's nothing more than who you're more comfortable with and why. And does that establish credibility? Well, if it does, then that certainly impacts justice. And so I think it's a critical issue that we do need to aspire to. I agree it's hard to get your arms around because it's not 2 + 2 is 4. But just because it's difficult to get our arms around doesn't mean we shouldn't try. And so I'd like to see this get adopted so that it at least gives us somewhere to go. Now, I saw the comments related to the rule, and I think that's going to be a much heavier lift. For a lot of reasons. But I would at least like to see us aspire to getting to where we can literally treat everybody equally, because it's tough. It is very tough.
Thank you, Judge Bell. Ellen?
Yeah, thank you, David. So I am really glad that Jack and Judge Bell are here and can say things much more articulately than I can. I agree with what each of them has said. And when I think about them in tandem, and I will vote for this as well, my concern becomes placement of it as we talk about quantifiability, which is how I'm going to interpret what Jack said. And I use as an example of this, the comment just above this, and its use of the word technology, which perplexes me, perplexes my students, perplexes lawyers that I talk to. What is that? What does it mean to be not competent or to lack competence based on the use of or failure to use technology? And I think a lot of resources are being invested in trying to figure that out. And so my question is I'm new to this, so I don't know, is the comment where this goes is the best place for this when we have that unknown of how we quantify it. Because my guess is Jack wasn't incompetent before he had training on intergenerational trauma. Does it go in the preamble, or is this may be the right place? I don't know.
Okay, thank you, Ellen.
Sydney Batch also would like to say something.
Okay.
Sorry, I can't find my hand raised position, so I apologize. But I just want to thank the bar for doing this. I think that we have to just keep in mind that we can't let perfect be the enemy of the good. You know, we have a lot of other committees where media has changed, right? We have text messages, with technology changes. And so this is a great aspirational goal that I think that we should support and vote on. And over time, if things change and the research comes out and social science comes out and says that things need to be prioritized differently, or we're redefining things just like we redefined gender, just like we've redefined almost everything, frankly, in our legal vernacular, that we can come back and we can actually address this. But I do want to say that, you know, being an attorney who works in a courtroom where in child welfare, where the vast majority are disproportionately people of color, and the way in which many of the judges and many of the attorneys do not understand their life experience and do not understand generational poverty. I mean, generational poverty, but also just the generational trauma, as Jack has talked about, is really important. Now, I have of course, you know, I'm a social worker as well, so I get it differently, but I went to school, right, and got a master's in that. But I do think that the way in which I approach my clients, whether they be people of color, whether they have, whether I'm representing my trans youth, it makes me a better attorney. We're not incompetent because you don't know that. It just means that you're a better attorney because you do know it. And I think that we get better representation when we actually explore the fact that somebody's life experience is very different than ours. Just like I'm never going to understand how it is to be a white man in this world, you're not going to understand how it is to be a Black woman. But that doesn't mean that you can't pick up a book and read it. Doesn't mean that you can't go ahead and sit in a CLE and learn somebody's different experience and understand that just because your life experience is one way does not mean that someone else's is invalidated. So I just want to thank the bar for everything with regards to this, and I'm certainly support it and hope everyone else does.
Thank you, Sydney. Anybody else? This is really a very important issue for us, and it's about alertness or awareness, or just knowing sort of what's, you know, what is the unknown. I would rarely quote Donald Rumsfeld, but a lot of times, the one thing he did say that I like is, it's the unknown you don't know about that is generally your problem, and that's often the case. And this is really to try to alert us to look beyond what we have, to not do the autofill or the default. Anything?
Can I say one more thing, David?
Yes, ma'am, certainly.
I had a case, because I think this may be instructive, an example. I was in 5A a couple of weeks back. I'm in 5A this week too, but which is our domestic violence court, if those of you who don't come down here much, and where people come in and seek ex parte orders, or they come in to do hearings as to whether those should go forward or not. And I tend to be pretty formal in that I don't like people to have a lot of drama when they're testifying. Like if one person's testifying and somebody's, you know, making a lot of gyrations or commentary, I will get a handle on that fairly quickly. Usually they understand. Some by putting in timeout and lockup for a few minutes. But we had on one particular day a young lady who came in seeking an ex parte order, and she was had a very rough exterior, and she was expressing herself in a way that was inappropriate to the court. So much so, at one point, I was asking a couple of questions of her, and she said, "Why are you asking these retarded questions?" And my normal reaction would have been to do one thing. And in fact, my bailiff and clerk were getting ready because they were expecting one thing. But I saw it differently. I saw something in her that she was broken, and she needed me to take a little time and patience to listen. And then she gave the information. Now, she was inappropriate, and I did tell her that later about the way she expressed it, but I saw it differently. It landed differently because I have had some life experiences that allowed me to know that. And so that's what I'm saying by this is aspirational, and it gives good information.
Catherine?
Yes, sir.
I'm sorry, your hand is up. Did you have a question?
Sir. Yes, sir. I just wanted to mention that it is really a very uncommon thing for the grievance committee to issue discipline, or for the DHC to discipline a lawyer for incompetency. That's one of the least least common rule violations that we work with. And so I thought Carmen's comment was important, that it's to help lawyers understand what is required. I was explaining how the comments really work in the discipline process, meaning how do they impact the work that I do on a regular basis. But this comment, because it's to the competency rule, I think is probably much more important as guidance than it is as something that would play into the disciplinary process. Usually, if there's a competence problem, there are a whole lot of other rule violations, diligence and such as that. And for us to prosecute cases based on competence, it becomes necessary to bring in expert witnesses about what's the standard of care. And it typically is not necessary, because a lot of times it might be an isolated instance of malpractice, which the rules say would not be applicable, or there are just other ways to approach the thing that doesn't involve Rule 1.1.
Brad?
Yeah, I just wanted to say that I don't know how many people on the committee represent people being investigated for and charged with and prosecuted for ethical violations, but I do and have for quite some time. And from the perspective of somebody who defends against these charges, I just want to co-sign the notion that you've heard from the members of the Office of Counsel, that this is not, because I'm a big fan of clarity and a big enemy of vagueness when it comes to prosecuting anybody for anything. And I haven't really seen any of that in the Office of Counsel. And so I just think that I wanted to kind of add from the defense perspective that if the concern of anybody about moving this forward is that all of a sudden we're going to just have creative people out on the fringe trying to prosecute people and lawyers for misconduct, I think that's not a founded concern, and I would just encourage people to vote for this without having that concern. Thanks.
And I do think that that's where the committee benefited, this subcommittee particularly benefited by having some folks on there who represent folks who are often before the DHC or who work with the Office of Counsel to defend members who are up on charges. I think that you can see the handiwork there. So good comment. I appreciate that comment, Brad, but I do think it also is testament to the hard work that this committee has done in trying to get all of this stuff right. I don't want to cut anybody off, but we're still on the first page of our written agenda, and we have a good bit of other work to do. But these are important places for us to go. This is the material here on the first page that dealt with both the preamble and with this issue are things that really are speak at the heart of our professionalism and of our obligations as attorneys who practice before the bar. So any additional comments are welcome. I don't see any additional hands up. So the motion is to publish, to send this to the executive committee and on to council for publication with the language you have in front of you. And that's been moved and seconded. Unless there are other comments, we'll proceed to vote on that motion.
David, I believe the motion passes 25-2.
But thank you, folks, very much. That will be presented in and move forward. The next matter, and again, Brandy, thank you, Brandy, particularly for joining us today and for staying with this committee. Even though you've left the Ethics Committee, we appreciate your continuing involvement with us with respect to this important matter.
Thank you, David. I also want to thank Brian and Carmen so much for the input they gave to all the questions.
Thanks, guys. The next matter will be subcommittee reports, and we return to one of those persistent FEOs that we had. This is FEO 2019 FEO 4 communication with judge. This is a matter that's been around in one iteration or another for 4 or 5 years. I had a appearance before former colleague Judge Mike Robinson, former member of this committee, and former member of this subcommittee, and mentioned to him that this matter would be coming before the Ethics Committee today. And Mike was surprised it was still sort of bumping around, but happy to know that it might be on the agenda for today. This is the communications with judges. And this is, Mr. Collins, this is your subcommittee.
David, before Jerry speaks, would you like me to introduce the matter?
Sure, that'd be fine.
All right, just very briefly, because like you said, this one's been around for a while, but 2019 FEO4 deals with a lawyer's professional responsibility in communicating with judges. One of the things that I guess just as our background, as we look at this particular opinion has been published a couple of different times, most recently in October of 2020, and we received a number of comments, and in January this year, this committee sent back to subcommittee the opinion for another look, because a lot of the comments we received following that October publication were negative and disagreed with a couple of different aspects of the opinion. We essentially redrafted the opinion. There's a couple of parts that stayed the same. I'm going to share my screen just to very briefly go through this opinion. I don't want to belabor it because I know that you all have hopefully read the opinion. The introduction was essentially kind of, I think, tightened up a bit. I know there was some question about exactly what direction the opinion was taking based upon the prior introduction. So we have, like I said, tightened up the beginning language to this opinion to kind of set out exactly what this opinion is talking about. And essentially, this opinion is talking about those informal communications that can occur between lawyers and judges. Really kind of set out that there's three different types of communications that typically occur between lawyers and judges. Those that are clearly permissible, such as formal communications, things that happen on the record. There are those clearly prohibited communications, like those spontaneous ex parte communications that would occur in the courthouse between lawyer and judge as they pass each other, perhaps on their way to lunch. And then there are those informal communications, the times when someone is contacting a judge to inform them of a scheduling concern or an administrative issue that they need to bring up, and perhaps they shoot an email to the judge to say, I'm going to be late tomorrow. I can't make tomorrow's hearing because I have an emergency childcare issue or something that was unexpected that came up. The biggest change that I want to point out here as far as this revision, the focus of the comments from the prior draft were really on the notion of simultaneously provided communications. The prior draft said that essentially, if you copy opposing counsel on your communication with the judge, then it is still considered ex parte, primarily because simultaneous communication or simultaneous delivery does not necessarily mean simultaneous receipt. That was, I guess there were a number of folks that disagreed with that particular conclusion. So we rewrote that conclusion. You will find that down now in what you see as inquiry number 3. Inquiry number 3 now says that essentially you can copy opposing counsel. If you copy opposing counsel on your communication with the judge, then it will not be considered an ex parte communication. Essentially, the simultaneous provision of that communication is communicating in the presence of opposing counsel. What the opinion goes on to note, and this part has remained the same from the prior version, is that just because something is not ex parte, since you have copied opposing counsel, does not mean that the communication is automatically ethical or permissible. Because if the communication is addressing the substance, the merits of something that's before the judge, and has not been invited by the judge, that communication has not been solicited by the judge or is not otherwise authorized by law, that type of communication, a substance-based communication sent to a judicial official, even with copying opposing counsel on it, can still violate Rule 8.4D, and that it's prejudicial to the administration of justice. So the opinion, like I said, is in your materials. It's in the addendum materials. It was published to you on Monday. The subcommittee met twice this past quarter, and that's where the opinion kind of ends up. But Jerry, I think I would love to hear your thoughts on chairing the committee and the thought process for the opinion.
Jerry, the floor is yours.
David, one of the things I'd like to say is that we had great participation on this subcommittee, not only from subcommittee members, but from advisory members, which includes Judge Robinson, as well as our officers. And we also had other attorneys and one judge who were folks who were just interested in assisting the subcommittee to try to get it right. And as Brian said, our redraft pretty much focused on inquiry number 3 and the opinion to inquiry number 3, which rules that the simultaneously provided communication is not an ex parte communication. And then it has important limitations, both in the opinion in number 3 as well as the opinion in response to inquiry number 5. The subcommittee believes that we struck the right balance this time after receiving the substantial number of negative comments on the first publication, and that this opinion is sufficient to protect the public, to promote the administration of justice, at the same time as allowing attorneys and judges to have the flexibility to get their day-to-day work done on administrative matters. I would also like to thank Brian and Carmen and staff. They've done a ton of work in helping to get the current draft to this position. And on behalf of the subcommittee, we would like to recommend that it be published for additional comment.
Okay, thank you for that motion. Is there a second to that motion for publication?
Second.
All right, thank you. Now we're open the floor for comments. All right. I don't see any hands. Well, that's an excellent job by Mr. Collins. You're gonna get to chair all the committees that have wandered in the wilderness for 40 years from now on, Jerry. So I don't see any more hands raised. If there are no more, then the motion is to send on for publication. If you put up the poll, we'll vote.
And that is unanimous in favor.
Excellent. Well, thank you, Jerry, for at least rowing this boat this far to shore, and to all the members of this committee. That I would, at some point when, Brian, when you are lolling on the beach over the summer, you ought to catalog how many members, actual members of the subcommittee there have been on this committee on this subcommittee during its time, because that's I mean, I bet you that would be legion. So thank you, and Jerry, thanks for all the hard work here. We have had a lot of input, a lot of segments of the bar have had to touch this, and we're trying to capture something that would cover both, for instance, the business court and the family law section. Has been a stretch that it really has taken Jerry from the mountains to the coast. So thank you guys very much, and to a very hardworking committee and to excellent staff support on that.
From the Front Range of the Carolinas.
Yeah. The next matter, you'll get no negative reviews from us for this, Jerry, but the next matter is 2020 FEO1, responding to negative online reviews. Suzanne, this is your staff presentation and Gina's subcommittee. So Suzanne.
Yeah, this is the opinion that deals with lawyers responding to negative online reviews. It's already been published for comment twice. The crux of the opinion has stayed the same since the beginning, and that is that lawyers can respond to negative online reviews, but they cannot include any confidential client information in their responses. The redrafts that we've had recently have basically just fleshed out different scenarios which involve reviews posted by non-clients or reviews posted by prospective clients. We also added an inquiry talking about a lawyer's right to file a defamation claim against a client based on a negative review. The biggest difference in the draft, the current draft, is the addition of inquiry number 7. And this, we have gotten a lot of questions around similar scenarios. And basically the question is whether a lawyer can offer to pay a client to take down a negative review or rewrite a negative review. And the subcommittee talked about this for a long time, and they decided that it was important to differentiate between 2 scenarios. One is just the simple quid pro quo, where the lawyer says to the client, I'll pay you $50 to take down the review, and that is not allowed. But that is different from a lawyer negotiating and settling a dispute with a client that may have to do with the value of the legal services rendered, which is done all the time by lawyers and which is permissible. So we wanted to make that distinction clear in opinion number 7. And we also wanted to make it clear, this is primarily Lamar brought up this distinction. We also wanted to make it clear that a lawyer is not prohibited from settling a defamation claim against a client with one of the terms of the settlement being that the client agrees to remove the negative ad.
Okay, thank you, Suzanne. Gina, this is your subcommittee.
Suzanne, I guess I would only ask, is the language that we talked about with addressing a legitimate defamation? There we go.
Yeah, Brian. Thank you, okay. Brian.
So this is the only thing that I was going to add, is that this is the latest and greatest response to Lamar's concern about how we thread the needle between having lawyers act in a restrained manner, but allowing them to defend themselves if somebody's willy-nilly defaming them on the internet. And this is the language that Suzanne and Brian and Lamar came up with that I believe the committee is okay with. So if there's no disagreement here, I would move to publish this for the 3rd time as revised.
Okay. Thank you, Gina. Is there a second to that motion?
Second.
All right. Now, questions, comments from the subcommittee or from the committee? Okay. I don't see any. If anybody has anything, this is your last chance. If not, we'll proceed to vote on this language. This would be a motion for publication of this language on FEO, 2020 FEO 1. All in favor or opposed, please signal your votes on the poll.
David, I believe that passes unanimously in favor.
Right, great. Thank you very much. Thank you, Gina. This is a matter that doesn't have quite the history of the one just previously, but has been around for a while, and I'm glad that we're able to move this matter forward for publication as well. The next one is another matter that retracted a good bit of comment. I believe that I reported last quarter that the communication with judge matter and the commenting on client information those two produced more comments last quarter than any other 2 FEOs that we had ever considered. We got more feedback from lawyers and from the public on those 2 than any other matter, which is really incredible, particularly given some of the other topics that we've had to talk about through the years. But this is 2020 FEO 6, commenting publicly on client information contained in the public record. Evan Rawls is chairing this committee, and Suzanne, this will be your staff presentation.
Sure, I'll just get it started. I'm sure Evan is going to have a lot to add, but this is the infamous inquiry that talks about whether a lawyer can discuss his client's case during a podcast, and the lawyer is only intending to discuss information that's contained in the public record, but the lawyer asks the client for consent, and the client says, no, you can't talk about my case. And the lawyer submitted an inquiry asking whether he could ignore that request. Basically, the lawyer maintains that he should be, that Rule 1.6 doesn't cover information that is in the public record. We published a proposed opinion for comment, and that opinion says that Rule 1.6 does not have an exception for information that is in the public record or generally known or anything else. Rule 1.6 covers any and all information acquired during a representation. So the opinion concluded that the lawyer could not discuss his client's case at a podcast or any other time. We got a tremendous amount of comments, and they were all negative except for one from Bobby Joe. Thank you, Bobby Joe. And so, of course, this was sent to a subcommittee. Subcommittee looked at the comments. We discussed all of the comments. We looked at this from every different way that we could and just could not come up with a way to arrive at a different conclusion than what is in the proposed opinion under the current Rule 1.6. There's just no other way to interpret Rule 1.6. That being said, we had a great meeting. If you look at the subcommittee report, you'll see we had over, I think, 14 participants, lots of different folks, lots of different viewpoints, and some really, really great discussions. And it's just such an interesting topic. But ultimately, the subcommittee decided we cannot write this opinion the way people want it to be written. And I should say that one of the major concerns with the way the opinion is written is that it seems to prohibit lawyers talking about their cases at CLEs and other types of legal education forums. And that's really important. And it's really important to the members of the subcommittee to try to allow for proper legal education while still protecting client confidentiality. Ultimately, we decided that probably the best course of action is going to be to put this opinion aside and start looking at possible amendments to Rule 1.6.
Okay, thank you. Mr. Rawls, can we hear from you on this?
Thank you, Mr. Allen. Suzanne set it up very well. We do not have any action for the Ethics Committee today. But briefly, like Suzanne said, we had a robust and very fruitful discussion with the subcommittee and others that joined in. And there we looked very closely at the way we interpreted 1.6 with the In Re Con inquiry. And we came to the consensus that that was decided correctly as the rule presently sits at 1.6. We also looked closely at all the comments and noticed that some, if not a majority of the comments, seem to conflate or misinterpret the title of Rule 1.6. I think some folks were looking at it as confidential information instead of confidentiality of information. And so, but we took to heart the comments and came to the consensus that we need to carefully study modifying Rule 1.6 and related rules like 1.9 and 1.18 and scrub through the comments and get some consistency. So Suzanne has lifted 10 states out of that have modified 1.6 to give some leeway in terms of lawyers discussing or disclosing non-confidential and non-privileged information, information that's in the public record or generally known. So we're gonna look at ways to craft a rule change that is best for North Carolina. New York and DC have rule changes that we've looked at very closely. But that'll be part of our next subcommittee meeting.
Well, thank you, Evan. It really is a fascinating topic, and it's a great one. This is one that's just caused lots of commentary. I've spoken to lots of counselors and the other members of the profession just about this issue because it's a fascinating one. So you're asking that the matter stay with subcommittee for continual work.
Yes, this is not going to be done in a day, so this is going to take some time. But I don't know if any of the other subcommittee members want to weigh in because this was a vigorous discussion, and wish more people had joined in and watched it, because we really did look at this from all sides of the prism, and carefully analyzed where to go.
Warren, I see your hand is up.
Yeah, I just wanted to make sure that when y'all consider this again, you consider it in light of being consistent with Rule 1.9 C1, where a lawyer is allowed to use information against and to the disadvantage of a client, a former client, if it is generally known, i.e. you can sue an old client and you may be able to use some of that information. I think Professor Murphy, I'm gonna call you Ellen, had brought that up at one point in the past, and I think it's important to be consistent there when you're doing a conflict analysis about what you can do to the disadvantage of a former client. We say you can do something if the information is generally known, but then here we're saying you can't do anything even if it's not really to the disadvantage of the client by discussing it at a CLE. Just want to make sure we're consistent.
Let me answer that just briefly, because Suzanne helped me navigate the terminology in that. In terms of use does not mean reveal or disclose. Use means developing, say, cross-examinations or theory of the case. So use and disclose are two distinct terms in 1.6 and 1.9, and I thank Suzanne for schooling me on that. But yes, we will be looking very closely at that.
Yeah, Warren, we realize that a change of Rule 1.6 is going to affect potentially a lot of other rules, and that's one of the things that's going to make the task more difficult. But as Evan said, use and reveal is a completely different thing. 1.9 does not allow you to disclose information that's generally known.
Right.
Okay. Well, thank you for schooling me.
And thank y'all. This is another really good subcommittee, and it has been robust discussion, and that's a great thing. If you need to bring in the wily left-hander to in the ninth inning to close it out, Mariana Rivera Collins is warming up in the western hinterlands. So thanks very much.
Well,
guys.
we invite anybody that wants to participate in the next subcommittee meeting too, because it's very interesting, and we've got a really good group, and Suzanne is our leader and is leading us through this thicket very well. Thank you, Suzanne.
No, it was just such a great subcommittee meeting because we had so many people. And it just really helps you to come up with a better opinion or a better rule amendment the more people that you have participating. So I would encourage anybody that has any interest in this to check with me or check with Lenise, hi Lenise, to find out when the next meeting is going to be.
Okay, the next matter that we have is the inquiry of Busker. This is the use of machine learning in the law practice. Brian, this is you, and Mr. Savage will be headed back to you in a moment for a subcommittee report. But Brian, can you tell us about AI machine learning?
Sure. So well, how long do we have? We want to talk about AI. My goodness. Now this inquiry was submitted with a variety of questions about a lawyer's use of AI or machine learning in their law practice and any sort of professional responsibility considerations in utilizing those newly developed and continually evolving tools. So the subcommittee did meet over the past quarter. We discussed how to proceed on this particular matter, but it's suffice to say this could be either a very broad opinion or a very narrow opinion, just responding to the questions that were posed. But I'll let Warren give a description of the subcommittee's conversation and where the subcommittee intends to go.
Mr. Savage?
So we had initially thought that we wanted to have AI ethics, an AI expert come in to educate us on things, and we were having trouble finding him or getting him involved, him or her. And we finally realized we had that expert already helping our committee, and that was Brian, who was expert, maybe not so much in AI, but in sort of guiding us to a spot where we feel comfortable right now. The idea, we're going to keep this in subcommittee, isn't that right, Brian? We would like to keep it in for one more meeting to hammer out a couple of things, but the idea is that we're going to do just an ethics advisory opinion specifically to Busker himself that provides some very, very general guidance under the sort of anchored in the competency rule that you need to be competent in the technology you use, and really not go too much deeper than that. We are going to address, I think Brian's done a great job of addressing each one of his inquiries, but still we keep going back to 1.6 and of course to the confidentiality rules, and then to the rule that you he's been very careful not to equate using Lexis as or something like that as being having to supervise an employee or a legal assistant or a paralegal or something like that. But it's the sort of the same sort of idea. You got to know what you're using. You got to make sure it works, and you got to make sure that the outcome that you get out of it is seems to be reliable and reasonably obtained. And so, to my eye, I think the idea here is that we don't want to get out over our skis and try to get too deep into the AI world. If you've read any of the articles out there, it's kind of like reading science fiction. They bring up all these issues, but really we hadn't been specifically asked anything that we can't just answer to say, just understand what you're using. And if you didn't even make any a barely minimal analysis of what you were using, and all of a sudden some foreign government has all your clients' confidential information, that may be on you, but we're not going to get too much into the weeds on analyzing each different type of thing that has AI. So we'll probably keep coming back to this issue, Brian, don't you think, over the course of the next 20 years or the rest of my lifetime. I mean, this is going to be an evolving thing. So towards that end, I don't think we have a motion yet. We'll want to consider it to do a little more tweaking, but we'll be back with an ethics advisory for you to vote on in July, I think.
Okay. Thank you, Warren. That matter then will go over until the next meeting. I would look forward to your exegesis. I learned a lot about Bitcoin from Ted. So that's look forward to learning all about this stuff, so that just as I end my career, I'll know more about stuff that I don't need to know about. That'll be great. Thank you, Warren. The next matter then is inquiry of grievance through Alex. This is lawyer possession of contraband during representation. Nicole, this is yours. And Kia, I'll be coming to you for the subcommittee report, but Nicole, tell us about this matter.
So this is the opinion about a lawyer possessing an illicit picture of a minor engaged in sexual activity. The proposed opinion provides that it is because of statutory, both state and federal law prohibits any lawyer or anybody from possessing contraband, that the lawyer cannot take possession of the the picture. The lawyer is representing a mom in a custody matter and believes that the picture has evidentiary value and wants to be able to use it against the father. But because the lawyer can't take possession of it, and there is no exception in the statutes that allow a lawyer to take possession for purposes of representing a client, the opinion finally provides that you just can't take possession. The opinion has gone through several changes. We've made several revisions to the opinion. It started out as a 3 inquiry opinion, and it then got to 6. Now it's back down to 3. So I won't go through all of those changes, but currently the opinion is going to focus on the lawyer's inability to take possession of the picture because it is illegal, and also focuses on the lawyer's statutory obligation to report the existence of the picture to law enforcement and DSS. So after the most recent subcommittee meeting, they directed me to make those changes, but we had hoped to, but we had not been able to meet again to discuss those changes. So it probably should remain in subcommittee, but I'll let the subcommittee decide that.
Thank you, Nicole. Takia?
Yeah, Nicole, she's right. And I think that she's done an excellent job with setting up the original proposed opinions and then the changes. And now we're going back and forth. So this was a tricky one. I think it was the broader we tried to make it. That's when we ended up with more questions that we probably couldn't answer. And I think that we're in a good place now. We just need to make sure that everyone on the subcommittee is good with what we have now. We did have some changes with the subcommittee through the different terms. So that kind of affected where we ended up, where we landed, how we started with 3, went up to 6, came back to 3. But like I said, I think we're in a good spot now for everyone to make sure we're on the same page. And I agree we should just stay in subcommittee just to make sure. And then we should be able to bring it back to the committee at the next meeting for you guys to look at and vote on.
Okay. Thank you. And so that matter will go over unless there are any questions for Takia or Nicole.
Mr. Chair.
Yes, sir.
Bert Camp, I have a sort of a comment, I suppose. This issue, and I know Tom Anglem is here, and I think Mr. Vickery has left, but this issue has been, from a criminal defense standpoint, a pain in the butt for the last 10, 20 years. I would just suggest that the subcommittee be very cautious that a order from a district court, now, and someone correct me, who is much more knowledgeable in federal court than me, but a district court order in state court and a superior court order, I don't think gives you coverage. Even if you were to get that order to, and I think I read some about the opinion, even if you get that umbrella coverage saying that you can have it, that's not going to give you any type of cover from the federal system. And so, yes, ma'am.
The subcommittee did talk about that. So that language has been removed from the current version of the opinion because you're exactly right. The court doesn't have the authority to override law, federal law. So, or state court doesn't have the authority. So all of that was taken out.
And the other thing I just mentioned, that if anyone ever wants to try to get some type of a limited, strict exception on this particular rule and through our state legislature and our federal legislature, or in Congress, I would definitely somewhat support that, because it is very, very hard and very, very expensive to represent individuals with child pornography in the current nature of our parameters, our strict parameters that we're under. I understand all the concerns and the abhorrent substance of the pictures themselves, but it's just extremely difficult. So that's all. Thanks.
Thank you, Bert. Tom, did you have did you take, I thought I saw Tom's hand up, but now I don't see it. Are you,
I did, but once Nicole started talking and because we were all part of that discussion and she handled it well. So I shut.
All right. Well, this is going back to subcommittee. If there are other questions or comments for us today, that's fine. If not, please, stay in touch with Takia or with Nicole and to surface these issues. Although I'm sure that they're riding hard on it, but it's a thorny issue. So thanks very much, and look forward to hearing back from you guys at our next meeting. The next matter is inquiry of grievance through Barry McNeil. This is a lawyer's professional responsibility in identifying and avoiding counterfeit checks. Nicole, this is also you, and Jack will be coming to you for the subcommittee report.
This is one that's been around for a while, but you all recall that this is the opinion where the lawyer receives an unsolicited request to file suit against the third party for money owed. The lawyer, without doing a whole lot of work, ends up with a certified check issued from an out-of-country bank. Without verifying that those funds really are good, he disperses those funds, and as the client directed, sending part of the funds to an out-of-country bank, sending another part of the funds to an out-of-state bank. Lo and behold, the cashier's check that the lawyer received was counterfeit, was fraudulent, and therefore the lawyer dispersed against those funds without actually having those funds, which means he used another client's money or several other clients' money in order to make those disbursements, and he wasn't able to recall it. So the opinion focuses on the lawyer's duty to provide competent and diligent representation and to recognize the red flags raised in this in the set of facts, namely that the representation was unsolicited, that the check or that after one phone conversation, the lawyer gets this certified check for just about all of the funds that are owed. The check came from an out of country, and the lawyer did not verify or make sure that the funds really were good. So that's part of the opinion focuses on 1.1 and 1.3. The opinion also focuses on Rule 1.15 and the lawyer's failure to verify that the funds really were good before he dispersed. And because he did not do that, he violated the trust account rule by using other clients' funds to satisfy this one fraudulent client's needs. So the revised opinion also references RPC 191, which references the Good Fund Settlement Act. And as many of you know, the Good Fund Settlement Act lists a number of different types of instruments that can be dispersed against immediately because they are deemed to be almost certainly to be good. Cashier's check is included in that. However, the opinion provides that notwithstanding that, the lawyer still should not have dispersed because of the other red flags already raised in the representation.
Thank you, Nicole. That's Jack. This is your subcommittee.
Yes, and I just want to say that I had the good fortune of inheriting this subcommittee after Stuart left, and I'm now able to take credit for all the hard work that she did. I chaired this committee, I think, Brad, if I'm right, or Nicole, if I'm right, for approximately 19 and a half minutes, at which time we were able to conclude the matter, again, not because of anything I did, but because of all the hard work Stuart and Nicole and the committee did before I got there. Although I do note for the record, Your Honor, that 19 and a half minutes is the efficiency with which I will chair the next committee, should I be fortunate to get one. No, seriously, this thing was really trimmed down to the question of whether or not the attorney had been upholding his professional responsibilities when he did not, or she did not, inquire as to the status of monies that were put into a bank account with a check, whether or not very commonsensical. When the question started out, it was much broader, but the committee was able to narrow things down, to tailor them to the point of really being able to focus on an attorney who failed to even check whether or not the money had cleared before she started dispersing funds, which made it much easier to deal with. As Nicole said, the second question, so the first question just deals with the issue of whether or not a lawyer was remiss in contacting the bank to find out what the status of the authenticity of the money was, something we would all do before dispersing it, and before dispersing it out of his trust account immediately. And as Nicole said, you know, that we in query number 2, we were able to carve out cash, wired, cashier's checks, those types of things. So again, this, I think that in its current form, what Nicole has written is fantastic. It really captures the trimmed down version of the question, and I make a motion that it move forward.
This will be a motion for publication. Is there a second?
Second.
Okay, thank you. Is there are there questions or comments from the subcommittee or from the full committee or from anyone? All right, in that case, we'll proceed to vote. This will be the vote for publication. All in favor or against, please signify on the voting pad. I will tell you, Jack, that the fact that you were able to do this and that you got it in 19 minutes reminds me of the wonderful story that my friend Jim Cooney told me after Cooney and I had tried a particularly difficult case. Cooney said to me, you know, David, the only reward for proving that you can juggle 4 grenades is that you get to juggle 6 grenades. And well, yeah, that's one way to look at it, Jim. So don't worry, there'll be another one headed your way. May take 20 minutes, but thank you. That looks like that has passed, and so that will be for publication. Sorry to be, I had the wrong note here. So now the next matter is the inquiry of Brocker. This is lawyer participation in Google screened pay per lead advertising program. Gina will be coming to you for a subcommittee report on this, and Suzanne, this is your presentation.
Sure. This inquiry involves a Google pay per lead advertising program, and the problem with this particular advertising program is that the lawyer's ad contains contact information that is not the lawyer's personal contact information. The contact information on the lawyer's Google ad actually would be routed through the Google platform. And then it is recorded and retained by Google for a period of time. So the issue here really is confidentiality of client information. A proposed opinion was presented at the January meeting, but it was sent to subcommittee for further study. The subcommittee met, and we are still working on this opinion. There are some tricky issues here. One of the tricky issues is whether a consumer who contacts a lawyer through a Google LSA ad is or is not a prospective client. That's one that we're struggling with. Another issue is whether there is any way that a lawyer who wants to participate in this type of advertising program, if there's any way that they can get informed consent from a consumer who contacts them through this advertising platform. We're working on a draft, and the draft is probably going to say that a lawyer is not permitted to participate in this program so long as Google continues to record and retain the client communications.
Okay, thank you. Gina, this is your subcommittee.
Yes, not much to add there, except that it is interesting when Suzanne gave her report about the calls coming into the bar, she said the top 3 were conflicts, confidentiality, and advertising. Mm-hmm. I've heard her say that before. And this particular issue has all of those three things wrapped up in a real tight knot. And so trying to allow lawyers to be in business means that we have to allow them to get out there on the internet. And the internet's a very scary place. Sometimes we're worried about false reports from clients, prospective clients, or their friends and neighbors. But in this issue, we're worried about what Google might do to the client's information, and maybe even to the lawyers too, because Google's not out to protect the client or the lawyer, with all due respect to Google. So we're working on it. It's tricky, and we'll report back in July.
Okay. That's thank you, Gina. That matter will go over to July. Are there, in the meantime, are there questions or comments from the subcommittee or from the committee? Steve?
Thank you. I've got PTSD from the ABO committee here when I look at this. We always try to steer clear of naming names of companies. We can't always do that, but I think with this opinion, probably the more generic we can make it, the better. One of the problems that came up with ABO and other technology related lead type things is it's difficult for the lawyer to reach the consumer because, well, it's difficult for the lawyer to reach Google for that matter. You just can't, if there were some physical way to establish the connection, maybe this could be worked around. But anyway, I just want to add that comment. Thank you.
Okay.
I think we should make it generic. Thank you for, and I think we might have come to that conclusion before we drafted it. But anyway, thank you very much for pointing that out.
Okay. Additional comments or questions? All right, then thank you, Gina. We'll hear from you as your subcommittee continues to move forward in July. This is an inquiry of Lucas charging fees to opposing party in residential real estate closing. This is Brian, your staff presentation, and I'm not sure, have I seen Alan Croy? This is his subcommittee.
Yes, he is here.
Okay, then Brian, go ahead and get started then.
Great, thank you. So this inquiry really came to us from the real property practitioners. This question about when you have a particular just residential real estate transaction, buyer has retained an attorney to serve as the closing attorney, but the seller chooses to retain their own counsel. What has been reported to us, what we've seen, I think, maybe even in the grievance process to some extent, but certainly what has been sent to us as an ethics inquiry on multiple occasions is, can the buyer's attorney charge the seller at closing for work that the buyer's attorney has done in reviewing seller's attorney's work? That essentially that buyer's attorney, the closing attorney for the buyer, is charging the seller because seller has not gone with buyer's attorney to serve as the closing attorney for the entire transaction, and now is saying, well, now you're making me do more work because I was going to use my template forms, and now I've got somebody else's work that I need to look at, and they have been including charges on the closing disclosures to that seller for work that the buyer's attorney completed in serving as closing attorney there. So this opinion addresses that very issue and basically says, buyer's attorney, no, you can't do that. You cannot charge essentially what we're calling the opposing party in a real estate transaction for work that you're doing just because they have decided to retain their own separate counsel. And so the opinion goes through that analysis, noting a couple of different ethics opinions that have preceded this, but generally kind of coming down to this notion that, again, the work that the buyer's attorney is doing and serving as closing attorney is for the buyer. It's not necessarily for the seller, and you can't charge the seller. If you wanted to charge your client additional funds because you are having to do more work in closing the transaction, that's a matter between you and and your client, and is going to be subject to 1.5 or 1.5's requirement that any fee not be clearly excessive. But nevertheless, the opinion is in your materials. That's the conclusion for it. And Alan, I'd be happy to turn it over to you for any thoughts from the subcommittee.
Alan?
Okay, thank you. We thought, the subcommittee thought that Brian wrote such a good opinion, and also that the current rules covered this very well. But we understood these practitioners need to have a specific opinion to show to other counsel who are trying to do this. So we think the opinion's a good idea. I'd like to say, Jack, I'm sorry, but I think we came in under 15 minutes in our meeting. Let's check the official record.
Yeah, I believe we were right at 14, Alan. So we're number.
Jerk.
Hey, I was part of Jack's committee too, so.
All right. So is there a motion then on this from you, Alan?
Oh, yes, I'm sorry. We moved that it be recommended for publication for further comments.
Okay. All right, there's a motion and a second. Thank you, Bill. Is there further questions or comments from the committee? Lamar.
I'm sorry, I'm not on the committee, so.
Yes, okay. Well, you well.
I happened to, and I'm not a transactional lawyer, but I just happened to talk to someone who is longtime transactional attorney and very good one and very respected one, and concern that he voiced to me that I'll just pass on, and this may be a concern that's not one because of the way that the opinion's narrowly drawn and tailored, but he was explaining to me that it's accepted practice for a buyer's attorney, the closing attorney, to charge the seller for overnight fees, wire fees, what are called payoffs, quote unquote, and that generally accepted and necessary practice isn't affected any by this opinion. My guess is it's not, but I've just raised the issue.
Yeah, I would not read the opinion to cover those sorts of kind of administrative fees associated with the transaction. This is more for the substantive work that a lawyer would charge essentially in providing a legal service to the buyer.
Thanks.
Okay. Well, that matter then will be for publication. Did we vote on that? I'm sorry, did I miss that?
Yeah, we do need to vote. Here comes the poll. And that appears to be unanimous in favor.
Right. Thank you, folks. Then that will be for publication. The next matter is the inquiry of O'Rourke. This is attorney serving dual role as a guardian ad litem and an advocate. Nicole, this is for you, and Dion, this will be your presentation for the subcommittee. But Nicole, we're with you.
So I'm gonna just speak briefly on this one. I think it needs to remain in subcommittee because of some things that we did after the committee. But quickly, this is the opinion where a lawyer is appointed to serve the dual role of the guardian ad litem, which is a fiduciary duty, and also the attorney advocate, which means that there's an attorney-client relationship and the rules of professional conduct apply. So those two roles, however, don't mix well in these dual appointment cases and the abuse, neglect, and dependency, and possibly in other cases such as the child custody. And but at any rate, as the guardian ad litem volunteer, the lawyer has to prepare and submit a guardian ad litem court report to the court. And then typically that person, the lawyer, will also testify as to the contents of the report. As the attorney advocate, Rule 3.7, lawyer as a witness rule prohibits a lawyer from testifying in a client's matter when they are a necessary witness. So the opinion provides that the lawyer can provide the guardian ad litem court report to the court, but they have to be careful not to make themselves a witness. During the subcommittee conversation, Sydney Batch, who had to sign off, she had another meeting that she had to attend, but she informed us that the opinion, although written is correct, raises a lot of issues or unintended consequences, such as that it will prohibit the guardian ad litem program from functioning the way that it does, because it may mean that lawyers can no longer volunteer. It will affect the AOC's budget and may upset some judges when the lawyer asks the judge that they not be able to testify. So what we decided to do was to keep this opinion in subcommittee, but before we present a full opinion to you or even recommend publication, that I would send the opinion to some of the stakeholders and get their comments up front before we even thought about publication, so that we would know what we're dealing with. So I did that. I sent it to a lawyer with the GAL program, Cindy Bazell. I also sent it to the parent defender with IDS, Wendy Soto-Longo, Sarah Pasquale from the School of Government, and Gail Sorelli. I'm not sure if that's how you pronounce the name, but she's with the Department of Justice, and she's the attorney for DHS, Child Welfare Division. I also sent it to Marie Mobley, who is an attorney advocate and guardian ad litem in Harnett and Johnston counties. So at this point, I've only received 2 comments, one from the GAL program, and actually the lawyer who submitted the inquiry, Reggie O'Rourke, he is the one that commented on behalf of the GAL program. And his comments focus mostly on a Supreme Court case that says that the lawyer can submit the court report without having to testify. He added some additional comments, and then the Gail Sorelli stated that her client doesn't have a comment at this point. The others that I sent it to want to comment, but they have not had an opportunity to do so yet. So my recommendation is that this remain in subcommittee. Let me collect all of those comments, and then our subcommittee can meet to decide what they want to do about those comments with regard to the opinion.
Thank you, Nicole. Dion?
Yes, we had a really good subcommittee meeting. It was the first one I've ever chaired. So Nicole really did a great job leading me through that process. We had several members of our committee, in particular, Sydney, who had such a part of her practice that this very opinion would impact or affect. She gave us some really good points that I believe now reaching out to these stakeholders, we will get good information. We do believe that the opinion is correct as drafted, but I do think it's great if we could get ahead of this before we move to publishing. So we do want it to stay in committee another round.
Okay, great, thank you. Well, that will go over till for the sampling of that additional opinion. Are there questions or comments from anyone on the call for Nicole or Dion? If not, okay, then we will, that one will go over for subcommittee. We'll move on to inquiry of staff, departing lawyers email account. Suzanne, this is you, and then Bill, you're in the warm-up circle.
This is an inquiry that we thought was going to be sort of a simple question, and it has turned out not to be so simple. The issue is, what is a law firm's responsibility as to a departing lawyer's email account? What do they have to do? What can they do? Are they prohibited from doing as to that lawyer's email account? A proposed opinion was presented at the January meeting, and it was sent to subcommittee. The subcommittee is continuing to work on this inquiry. The original inquiry had 6 subparts, and I think we will probably have at least that many. During the first meeting, the subcommittee did come to some preliminary conclusions, and that is that when a lawyer leaves the firm does have a responsibility to put some type of auto reply message on the lawyer's email account. They also decided that the message has to include contact information for the departing lawyer. And then we were starting to discuss the issue of the law firm's responsibility to supervise the email account. And by that, I mean having somebody at the firm read every email that comes in and decide what needs to be done. And we're kind of in the middle of that discussion right now as far as whether that needs to be done by a lawyer, whether it can be done by a member of the staff. what type of burden that would put on the law firm, and how long that has to be done. So another tricky part of the opinion is deciding how long the law firm has to keep the auto message on and how long the law firm has to continue to monitor these emails. So we're in the thick of it, and hopefully we'll have a draft at the next meeting.
Thank you, Suzanne. Bill?
Bill, you're muted.
There we go. Thank you, Suzanne. Suzanne, as always, has done an excellent job of summarizing where we are in the subcommittee. I want to talk about, there were a couple of things that we thought were pretty clear cut, and that is, when the client, after they've been properly advised that the lawyer is leaving the firm, when the client tells the firm or the departing lawyer, or hopefully both, that they've made their decision and they're going with the departing lawyer, then that's easy. When an email comes in, it just gets forwarded to the departed lawyer, and the departed lawyer is the one who has the duty to deal with it. And the same thing, if they've chosen the firm, then the email does not have to be forwarded to the departing lawyer because the law firm is going to be taking care of it. But there's some issues that we need to study and think about further. So it's going to remain in subcommittee, and thank you very much.
Great. Thank you, Bill. Questions or comments for Bill or Suzanne? Okay, great, Doug. Folks, that was we had 10 matters. We had a very busy January meeting and had 10 matters that we had to get subcommittee reports on. I congratulate all of the subcommittees that worked very hard over the last quarter in getting all of this material pushed forward for us. We're going to have a good bit of stuff for publication, and then the subcommittees will continue to work on a number of matters. But to all of you who worked hard this past quarter in bringing this many matters to us, that's a great thing.
David, I'm
yeah.
sorry, if I can just interrupt very briefly. For one, I echo your thanks to the subcommittee members. I know we had a lot of folks on multiple subcommittees, and your gracious volunteering of time and perspective is just so incredibly appreciated by staff. But I feel like I also need to point out the person, the ringleader that makes it all happen, Lanice. You all receive a lot of emails from Lanice, and she is the one that coordinates all of this stuff and gets everybody in the right place at the right time. So I think I just felt like we need to publicly acknowledge all the contributions that Lanice makes to make ethics happen between quarters.
Thank you for embarrassing me, and thank you.
Yeah, I think that's the title of Chief Cat Herder. It has to go to Lanice because it's trying to juggle her schedule, or her juggling all of our schedules, and also people who say, well, I'm not on that subcommittee, but I'd like to know about that, or can you keep me in the loop? And so if you had dotted lines as well as straight lines, it'd be a very confusing thing. So yes, Lanice, thank you very much for all the hard work that you do. You get to juggle all sorts of grenades for us.
Well, I got great
she has to
people to
deal with
work
me
with.
on a daily basis, so that's just even worse.
I will say it's folks that we're now onto the new inquiries, and I think this is the first time. I've been on this committee a long time, and this is, I think, the first time that we have had no new inquiries. So it's just shocking. We've done, I think it was it the patent office that considered closing in like 1915 because they said everything had been invented. I think that this is, we may have just done all of our work. We'll see whether that holds for the next quarter or not. There are also no ethics advisories, and we have one matter for transmission to council. We published a matter in the last quarter, the contemporaneous residential real estate closings matter that was published. One comment was received, which was thanks, you did good. And so there was a little, I guess there was a little technical change, Suzanne or Brian?
Yeah, I can explain this very quickly. After publication, some discussions amongst the various state bar staff members occurred where we were talking about ways that certain language maybe could be tightened up just to add some clarity to the opinion. So you have in your materials, the very first thing, if you go to the tab for proposed 2021 FEO1. That first opinion is the one that is for transmission to council. After that opinion, you'll see one with track changes. That shows you the different changes that were made. These are non-substantive changes. They don't change the conclusion or analysis of the opinion. They're really just language changes. And then you'll see a third version of the opinion, which was the one that was actually published, just so you can see the full comparison. But again, staff does not feel that these are substantive changes and that this matter remains appropriate for transmission to council.
You know, guys, as all of you are familiar with the fact, like the Tax Act that comes out, and they publish a technical correction to change some numbers around on. Congress does that all the time. This is the same kind of thing. However, if the committee, having looked at the materials, feels that it needs to be resubmitted for publication, we're certainly open to doing that. But at this point, it looks like those are just sort of minor and technical corrections. So unless people have a question about that, the chair will entertain a motion to transmit this matter on to council for adoption on Friday.
I move that we transmit it to council for adoption on Friday.
Thanks.
Second.
Second. Thank you, guys. Questions, comments about any of that? All right, then we'll do the poll and see where everybody feels on this.
Motion passes unanimously.
Great. Then that will be sent on to council, the full council on Friday for adoption. Thank you, guys. As I said, this has been a very busy quarter for us, and there's been a lot of, with as many subcommittees as we've had, we have worked y'all very hard, and I know that Zoom is not a great thing, and all of us are pretty tired of it. So unless there's any other business to come before the committee, we will be adjourned. It is, again, my hope that we will be together in Asheville in July. We will be following CDC guidelines, however, for all of that, which could mean social distancing, which could mean we'll be in a ballroom. But if you don't mind sharing, your sort of status with the state bar so that we can get some comfort. Let us certainly understand there are people who have issues with with all of this, and so we're not trying to pry. It's just we'd like to sort of, I think we'd feel better being able to communicate with you to say 80% of the counselors are, whatever it is, have been fully vaccinated. I think those are the kind of things that make people feel a little more comfortable about the fact that we may be gathering in person. The details are not worked out. We don't know whether there'll be, how many guests there'll be, what the social functions will be. All of that will come to light as we move forward. But it is, I think, most people's view that we will wish to get together because we think it's important for all of us, for the camaraderie of the bar and for the council to work as most efficient for us to be able to be together in person. We are mindful that although the average age of council may put all of us in a vaccine, more likely to be vaccinated group, we do have a whole lot of really young staff people. And so we don't want them to feel also, that they are at risk. That's another reason for us to try to do this. So thank you very much, and be in touch with Sharon if you are so inclined. I appreciate all of your hard work. Thanks, and we will see you